Before we discuss the given scenario, let's first look at what partnership law is. Under Section 3 Clause 1 of the Partnership Act 1961, partnership is defined as the relation which subsists between persons carrying on business in common with a view of profit. Now, moving on to the first scenario. Question 2A. One of the partners in travel agency, without informing other partner, arranges a separate tour package deal with a customer, using the firm's resources but keeps the profit for herself. When other partners discover this, they argue that partner has breached duty as partner. Based on the above situation, describe the rights of other partner. The issue for this scenario is whether the travel agency can sue the other partner for making secret profit using firm's resources. According to Section 31 Partnership Act 1961, it provides that a partner must account to the firm for any benefit derived from any transaction concerning the partnership or from use of partnership property without consent of other partners. This principle is supported by case law. In As against Benham, the court held that a partner cannot make a profit or commission for himself by the use of position or any information acquired in the partnership business. Similarly, same goes to in Bentley against Carven. It was held that a partner cannot make a profit from resale of any property owned by him to the firm without full disclosure to the other partners.
So now we move on to the next law that can be applied to this case is Section 30 under Partnership 1961. Section 30 is about the duty to render true account and full information. The definition of this section is every partner are bound to deliver true financial statement and information that may affect the partnership to any partner. So first case that we can do is law against law. The court held that the partner must share all information facts that affect the value of the partnership. If a partner hides such a fact, it is a breach of duty. Even though the court did not cancel the contract in this case because the party had already settled, it confirmed that hiding information could make the contract voidable. So the second case that can be looked is between Mascom and STNDHD and ANO against Kamawang Enterprise STNDHD and ANO. The court held that the partners have the right to get accurate account and full information about the partnership. This duty continues as long as the partnership exists and does not depend on providing fraud. So the other partner could demand account from Mascom. So, for the application of this case, the other partner has breached the partnership agreement when he secretly made profit without the consent of either partner by using the firm resources. This is because the law has provided that every partner must account such a profit to the firm, and if partner makes a profit without the consent of either partner to the firm, he is not entitled to keep the profit for himself. He also did not give a true information to the firm, whereas he made a secret profit with the help of agency resources. Therefore, he cannot keep the profit to himself, and the other partner and agency can sue him for breach this agreement. In conclusion, the other partner has breached the duty of faith under Section 30 and Section 31 Partnership Agreement in 1961. Therefore, the travel agency has the right to sue the other partner for making secret profit from the other partner and the agency itself.
Now let's move on to another scenario. The scenario sounds like this. Three partners running a partnership business of a bookstore. The business suffered loss and cannot pay a supplier debt of 50,000 ringgit. The supplier demands full payment from one partner only because he is the easiest to contact. The question is, based on the above, explain the liability of firms for debts.
The issue is whether the supplier can demand the full 15,000 ringgit from only one partner when the partnership cannot pay its debt. In this case, they have two sections, which is Section 7 and Section 11. In Section 7, every partner is an agent of the firm and his other partners. And the acts of every partner who does any acts of carrying in the usual way business of the kind carried on the firm by the firm of which he is a member by the firm and his partner. Second, a partner acts by the firm if done the ordinary course of the firm business. Court decide based on the fact of case what counts as ordinary business. If the act is something the firm habitually does, it is considered a case Mercantile Credit versus Garrett 1960. One partner sold a car fraudulently, even though the partnership agreement state partnership could not sell the car. The buyer acts in good faith. Held the firm was liable because selling car was within the appearance ordinary course of business of the car garage. Principle, even if restricted by agreement, the partnership can bind the firm in dealing with third parties acting in good faith.
There is another section that gives protection to the supplier if he is still not satisfied with the action taken. Under this section, it explains that every partner in a firm is jointly liable with the other partners for all debts and obligations of the firm incurred while he is a partner. After his death, his estate can also be held severally liable, as long as the debt were incurred during his lifetime and subject to the payment of his own personal debt first. The effect of this section is that partners are responsible for the full payment of the firm's debts. Creditor may choose to sue all partners, some of them, or even just the firm. However, once judgment has been obtained, the creditor cannot bring another action against the remaining partners. If a partner dies, the liability to settle the debt will pass to the surviving partners, not the deceased partner's estate. For example, in the case of MP Varma and Anor against KM Oli Mohammed, the plaintiffs sued in their personal capacity for a breach of the partnership agreement. However, the court dismissed the claim because a partner cannot claim sue in his own name alone. Instead, the action must either be brought in the name of the firm or with all the partners joined as a party to the suit. In this case, the bookstore business owes the supplier 50,000 ringgit. Since all partners are responsible for the debts of the firm, the supplier can choose to claim the full 50,000 ringgit either from all three partners together or from just one partner alone. That is why the supplier decided to go after the partner who was easiest to contact. If that partner is forced to pay the entire 50,000 ringgit, he does not have to bear the debt alone. After making the payment, he can take the action against the other two partners to recover the share of the debt. Based on their agreed profit and loss sharing ratio or equally if no agreement was made. Now, what happened to the supplier? The supplier is fully protected and can recover his money from any partner, while the paying partner has the right to claim the reimbursement from the others to make things fair.
In conclusion, yes, the firm is fully liable for the debt, and the supplier can claim the full amount from just one partner. The partner has the legal right to claim contribution from the other two partners.